everybody to the program on critical issues in nonprofit law. I'm Don Kramer. I'm an attorney in Philadelphia at Montgomery McCracken and editor and publisher of Don Kramer's Nonprofit Issues. You have materials today for this program. A good number of them are articles out of Nonprofit Issues. And you also have an agenda. I'm going to be following pretty closely to the agenda, not using a PowerPoint, but happy to answer questions anytime that you have any that you want to ask as we go along. Just a word about Nonprofit Issues. We're an electronic newsletter of nonprofit law you need to know. We publish a free question and answer every week. We have more than 125 ready reference pages on the site, some of which are in your materials. We add material to it every week. And if you're interested, it's easy to sign up for free. Just go onto the website, nonprofitissues.com, and there's a box there which you can easily sign up if you're interested. What I'm going to do today is cover a number of significant issues in nonprofit law. Michelle asked me if I would do this after hearing an annual review that we do for our newsletter in December. And so I'm going to adapt that a little bit, covering sort of general areas of nonprofit law, stuff you'll be hearing about if you haven't already heard about, and stuff which is affecting the sector as we move forward. So let me start with my favorite question is, what do we mean when we say nonprofit? Because the terminology in this sector is not particularly clear, and a lot of things have multiple meanings. So when we say nonprofit, we think we know what we mean, but nonprofit is basically a concept of state law, which means that nobody owns the organization. Somebody or some people control it, but nobody owns it. It doesn't pay dividends like General Motors might, or Amazon might, or Facebook might. It just means that all the money stays inside the organization and used for its specific purpose, as long as the organization stays alive. When we say nonprofit, we tend to think of exempt from federal income tax. Section 501C of the tax code contains many, but not all, of the organizations and types of organizations that are exempt from federal income tax. But 501C goes from C1 down to C29. That it includes organizations chartered by Congress, it includes title holding companies, includes social welfare organizations, it includes trade associations, it includes labor unions, it includes social clubs, it includes the Moose and the Elks and the Soroptimists and a whole bunch of organizations like that. And as I say, it goes down to C29. The biggest category is 501c3, and those are basically the charitable organizations, the kinds of organizations that I'm assuming most, if not all of you, are working with. But even charitable organizations are divided into two basic categories: public charities, hospitals, colleges, churches, other organizations which receive most of their income from a variety of gifts, and those which receive most of their income from fee-for-service income, they're public charities. On the other hand, there are private foundations who get all their new money from a single person or a single company or a very small group of people, like the Bill Gates Foundation gets his new money from Bill Gates and his family, and Warren Buffett and his family. And the rest of the money comes in from investment income. And those organizations are under different rules because they're less amenable to public pressure. Organizations which have to sell their services or have to live on contributions, they have to make, they have to be reasonably satisfactory to the organizations and people who are supporting them. Private foundation is all by itself. Nobody can control it. Nobody can really influence it. And so it is under different regulations from the Congress. The key thing about 501c3, which is different from all the others, is that 501c3 organizations may not participate in elections, may not support or oppose a candidate for public office at any level, and that they are limited in how much lobbying they can do. They're permitted, as public charities in particular, are permitted to lobby on public policy questions and support legislation, as long as they don't do too much. And that's a whole other area we're not going to go into particularly today. But my own view of public charities, if they're not lobbying, they're not doing their job, because so much of what they deal with is affected by public policy. And if they're not trying to influence that public policy, which affects what they do and how they do it, then my sense is they're not really doing their job fully. We can talk about that later if you want. And please feel free to ask questions as we go along. There are now about 1.8 million organizations registered with the IRS as tax exempt. The biggest group of them is 1.3 million charitable organizations, 501c3 charitable organizations, of which about 100,000 are private foundations. The rest are public charities in one form or another. There are additionally an estimated 325,000 or so church groups, religious worship groups, and adjunct organizations of the religious denomination. And obviously that includes mosques and synagogues as well as Protestant and Catholic churches. But religious organizations, they do not have to file to obtain recognition of exemption, and they do not have to file annual tax returns. So we can only estimate how many there are, and we don't really know, a lot about them with the same precision that we know about the other organizations. The key figure about this section, it seems to me, is that about 90% of the C3 exempt organizations have annual revenue less than $1 million a year. It's a huge percentage of them are relatively small. The big dollars are concentrated in the big medical centers and the big educational institutions. That's where the dollars are concentrated. The rules are all the same, but that big ones have a very different impact on the sector than a whole lot of the smaller ones that we'll talk about a little bit more. There are also nonprofit organizations which are not tax exempt and would have to pay regular taxes. The clearest example of that used to be the New York Stock Exchange. They switched their status a number of years ago, but for a long time they were a nonprofit organization, not exempt from income tax. And there are some states now which have charitable rules on them for state purposes, but they're not charities under federal purposes. The National Rifle Association in New York is a charitable organization under New York law, but it is a C4 social welfare organization under federal law. And the reason I mention all this is because if you don't know what box you're in, you don't know what rules apply. The rules are different from various organizations. The thing that I think is fascinating about this sector, particularly the charitable sector, is what the commentators call contract failure. That is that the general rules of the economy do not apply because the people who are using the services are very frequently not paying the cost of the services, the full cost of the services. And very frequently the people who are making up that difference and are contributing to the programs are not using the services. The clearest example is the homeless shelter. If I'm sleeping for free in the homeless shelter, I'm clearly not paying what it costs. And if I can contribute to the homeless shelter, I'm probably not living there. The key is that the normal rules of contract don't work. If I'm a homeless person, I'm dissatisfied. What are my choices? I don't really have a very good choice to go maybe to another shelter, but I don't really have a good choice in that proposition. And if I'm contributing, I don't know what kind of services they're contributing. Even if I contribute to my alma mater, even if I graduated last year, it's a different institution this year than it was last year. So it's really critical for organizations which are using contributions to run their program or to expand their program, that they be keeping the trust with their donors, keeping the trust with their participants, and that can have significant impact on them if they, disabuse that trust or they create problems for themselves. 2020, as you all know, was a year like no other. The Nonprofit Quarterly did a survey in November or December last year, which I found really pretty interesting. 82% of the nonprofits that they got results from said they had been affected a whole lot or a great deal by COVID. 74% said they had been affected a whole lot or a great deal by the economy. 45% said they had been affected by the racial injustice issues, and 31% said they were affected by the election. It was interesting that 28% had higher revenue last year than the year before. 28% were flat, and 44% were down. Many of them is more than 15% or so. So there was a significant change in the sector in the year, and it was really in large part related to the kind of organization you were. Advocacy groups had 76% of them had an increase in their revenue. Human services, 61%. Arts groups, 70% down. 57% more than 15%. Article in the New York Times just yesterday saying that 2/3 of the workers in New York City in the arts industry and recreation industry had lost their jobs in the last year. 2/3 of those people had lost their jobs. There was an article I saw from the National Council on Nonprofits saying that 930,000 out of 12 million people employed in the nonprofit sector nationally had lost their jobs in the last year. So there has been a huge change. There's also been, in the last year, a significant number of what I call hibernations. Nonprofit Quarterly had 39% of their organizations they surveyed had taken a leave of absence, as it were, had suspended their operations entirely for a period of time, and 11% had closed. We do an annual webinar on mergers and acquisitions, and this year we made it mergers, acquisitions, and dissolutions, because there's so much change in the industry itself. I represent and work with a number of community foundations, and I must say we've had more variance questions this year than ever before in my memory, because of organizations which have gone out of business, and the grant money that was originally left for this entity can't go there anymore, so we have to find another entity or another way to use that money to support the general charitable purposes that the donor had in mind. There have been a lot of reactions to this, obviously, as you're aware of. There have been a lot of funds created just for COVID work. The Philadelphia Foundation raised throughout the community more than $19 million, which it gave out in quite a few, several hundreds of grants to organizations who were dealing with a very basic safety net that we have in this country. There were new disaster relief funds which were created. I had a lot of interesting questions about whether charities can make grants to individuals and whether private foundations can actually make grants to individuals. And the answer to that is yes. Public charities can make grants to needy individuals who meet their requirements. Private foundations can do it as well. And they can make grants to individuals in disaster cases. The COVID epidemic or pandemic was designated as a federal disaster, so they can do that. And private foundations are limited making grants to individuals for study and research and travel, but they can help the homeless person on the corner. They can provide money for people's health care. They can do an awful lot of things like that. It's very interesting, however, that donor advised funds, which we'll talk a little bit more about later, may not make grants to individuals. So we had a number of people who had donor advised funds making the grants to the public charities who would then make the grants to the individuals. So the money can be used that way, but the law on donor advised funds prohibits grants to individuals. The COVID situation had a significant impact on the IRS. It had to extend its deadline last year for filing the 990s. It hasn't extended it for this year. There has been a huge delay in taking new applications for exemption. It's about 7 or 8 months now, even before the IRS designates an examiner to look at it, during which the people who try to start the organization are totally in limbo. It's been really difficult for the IRS to deal with all that. Congress obviously passed a number of statutes last year, which were very helpful. They allowed for the first time in recent years a $300 deduction for charitable contributions for any taxpayer above the line, without regard to the standard deduction, which has reduced the number of taxpayers who actually itemize their deductions down to only about 10% or so of all taxpayers who itemize deductions. And last year, people were able to take a deduction up to $300, and that has been extended again for this year as well. The other thing that they did was say that people who were permitted to take a deduction for cash gifts up to 60% of their gross income, adjusted gross income, can for last year and for this year give away 100%. Now, that's not something that affects most of us, but it does affect some people. And there are some people who have been willing in this particular year to give away more and deduct it at one time than they would have been allowed to do before. The payroll protection program made money available to a lot of nonprofit organizations. Last year, the number was you're a small organization if you had less than 500 employees. It's now down to less than 300 employees in the latest round of PPP loans. But there's a special week this week and next week for organizations with employees less than 20. So there's really small nonprofits may have a way to get in there. And I'm involved with one nonprofit, a couple nonprofits, which because of those loans really ended up the year not significantly worse off, and also being able to keep their people employed, which of course is the purpose of the PPP loan. One of the issues that is going on right now is the issue of unemployment compensation reimbursement in the nonprofit field. Many states permit nonprofit organizations to be self-insured for their unemployment compensation payments in effect. And if they have somebody who claims and collects unemployment from the state, then the organization has to pay the state for that. But since their employment is relatively steady, they found that it's cheaper and better for them in almost all cases to run the risk and to be essentially self-insured. Of course, when COVID came in March of last year and in April of last year, a lot of organizations just closed down because they couldn't carry on their activities. They weren't allowed to under state regulations, and there was no income coming in, so they couldn't keep their employees active. The Congress passed a rule saying that they would only have to reimburse the states for half of it, and there's an effort to get Congress to change the rule so they won't have to reimburse for all of it. But that's an open issue. The National Council on Nonprofits is dealing with that and trying to get Congress to change it for the, for 100%. The other issue that came up, which affected people in Philadelphia area, Philadelphia has a wage tax, and it's a wage tax applied imposed on people who work in the city. But since a lot of people who work in the city live in the suburbs and were locked out of their offices in the city, they're now permitted to reclaim the petition to get a refund of their wage tax. This is not very helpful to the city, but to the individuals and to the employees of the nonprofit organizations who were working from home. They can petition to get some of their wage tax returned. I don't know whether there are cities in Maryland who have wage taxes which may be affected by this, but there are around here. The other question that I thought was fascinating that came up during the year was, how much should we spend from our endowment? Most of the world has adopted the Uniform Prudent Management of Institutional Funds Act. And in some states, it says you can spend whatever is prudent to spend. In Maryland, it says if you spend more than 70% of the value of your endowment in any one year, that's deemed to be imprudent, and you have to notify the Attorney General that you're doing it. You can maybe justify it, but it is not, it is not preferred for sure. Pennsylvania passed a law this year which said for last year, this year, and 2022, people can spend up to 10% of their endowment. And the idea being that if your endowment is to sort of save up for a rainy day, there's not been much rainier day than there has been in this last year. And maybe we should be able to spend more than the 7%. It's really very interesting to me because the question I have always raised, I've always said that if people hadn't put money away yesterday, we wouldn't be having this discussion even today. It is clearly an important question. And my question is, how much of our seed corn should we eat? Because this money will grow and be available in future years for future problems. And the question is, how much of it should we take? My sense is that a 10% contribution, distribution level is reasonable, but we will see how that turns out. This, you should realize, the term endowment, again, is one of those which in ordinary parlance has a different meaning than in the legal parlance. A true endowment, the kind of thing which is covered by the UPMIFA and the other laws which deal with this, is money which is donor restricted. Donor gives you $1,000 and say, use the income only, or retain the principal and spend only a part of it. So that is a true endowment. Most people, most organizations will set aside by board direction other money to be treated as endowment. There are some organizations who say if we get a bequest of more than $25,000, we're going to treat that as part of our endowment. Legally, that's not endowment, it's quasi-endowment. It's treated as endowment, it's administered as endowment, but it's not under the same limitations. So if you want to spend more than 7% from your endowment, and your endowment includes a lot of funds which are not legally endowed, then you can spend more and still be within the law. Because most people's pot that they call endowment is made up of a lot of funds which were given to them or just set aside from surpluses, which are not legally constricted. But it's an interesting question of how much you want to approve and how much you want to spend on that. We got some other questions coming in here, which I'm going to save till the end because they're a little bit off the beaten path here, but if you want to know, we'll try to resolve them. One of the recurring issues in the nonprofit world is the whole question of participating in elections and dark money. When the Citizens United case was decided by the US Supreme Court in 2010, which said that corporations could contribute to political campaigns without limitations as long as it was not coordinated with the campaign, that changed the world immensely because although 501c4 social welfare organizations were allowed to support candidates and oppose candidates, and some of them did, they couldn't put a whole lot of money behind it because it was contrary to the law. So nobody really cared. When they changed the rules, we created 501c4 organizations. They grew up like crazy, and they began to spend their money on political activity. And the limitations of that is really very strange. The rule for a 501c3 charity, the statute says you have to operate exclusively for charitable purposes. And the regulations say exclusively means primarily. And the case law says no substantial part of your activity can be for non-charitable purposes. For 501c4 organizations, the statute says you have to operate exclusively for social welfare purposes. The regulations say primarily, and the regulations say that electioneering activity is clearly not social welfare purposes, but there's no statement that you can't spend a significant amount of your money for non-social welfare purposes. And so the commentators who want to spend more money for political activity have said primarily means primarily in the English sense being more than half. And so there are a lot of people who think you can spend up to 49% of your money in a C4 social welfare organization for political activity. And in fact, Congress has 3 times told the IRS they can't define what primarily means with regard to C4 organization. They actually prohibited them from reaching a definition. And so we are spending a lot of money for these expenditures. The independent expenditures that we're talking about here were $142 million in 2008. And in 2016, they were $1.4 billion. That is a huge increase. And why is this important? The only reason this is important is not because of the tax exempt status, because political campaigns are exempt from tax. The difference is political campaigns have to disclose their donors, and C3s and C4s do not have to disclose their donors. And so there's all of this dark money flowing into the political system because nobody knows exactly who is contributing it. This is one of the issues about the repeal of the Johnson Amendment, which is the amendment which provides that C3s may not participate in election campaigns. There's been a lot of pressure and a lot of interest in changing that. My view is that would be not a good thing, partly because I think charities are going to outlive the candidates and want to be able to work with everybody, but also because not only would the money be dark money, it would also become tax deductible money. And the C4 money is not deductible on the individual income tax, like any other political contribution is not deductible. But if you gave it to a C3 who didn't have to disclose it, but who could give you a charitable contribution deduction for it, it would be a quite different situation. There is a case which is in the materials dealing with the concept of whether a organization which does this kind of political activity has to disclose its donors under the federal election law, which held last year that they do. Anybody who spends more than $250 has to disclose their donors. Whether or not that will ever be implemented or not is an interesting question, but it was held by the District of Columbia Circuit Court. One of the judges on the case was Merrick Garland. One of the plaintiffs, or one of the people asking not to have to disclose it, was Senator Mitch McConnell. Just a little bit of irony in how the things play out, but it's an important case potentially. Okay, let me talk about some of the issues of organizations under siege. The Boy Scouts of the USA filed for bankruptcy this year after getting more than 92,000 complaints of abuse of kids. Extraordinary. The National Rifle Association was challenged in New York for a number of key employees who they alleged were reaching their fiduciary to the organization and spending excessively and spending improperly. There was very detailed allegations against some of the officers, including the president, Wayne LaPierre. And the Attorney General in New York went so far as to say not only that these people should be personally liable, but also the NRA should lose its charter because it did not have good governance. The government was not paying attention. It was an interesting case, and my original reaction was when I read it, if there was ever need to get separate counsel for the organization and for the officers, this was one of them. One of the officers wrote a book about this and sort of admitted that they had done all the kinds of things that were alleged. The interesting upshot of that is that the NRA, which is a C4, has filed for bankruptcy. It also has a C3 foundation, a charitable foundation organized in the District of Columbia. But the C4 has filed for bankruptcy and is seeking to reorganize in Texas, where they think they will not have as difficult a time with the Attorney General, presume. Story in the Washington Post that LaPierre had corrected his overpayments and given the money back, and presumably paid some fines to the IRS for doing that. But we don't know, all the details about this case, and it has a long way to go. There is an article in the materials that you have, which I thought was an interesting one because some of the members who contributed to the NRA for their membership dues and otherwise alleged that they had been defrauded by the NRA because they hadn't really spent the money that in the way that they said they were going to do. And one of the bases they used for the fraud was that the NRA had violated the Donors' Bill of Rights. Some of you may be familiar with the Donors' Bill of Rights, which was, I guess, originally promulgated by the Association of Fundraising Professionals in its former name, and the various other groups which have endorsed that, and it is out there. And it requires honesty and truth and no misrepresentations and things like that. But the court said that the allegation that they had violated the Donor Bill of Rights wasn't specific enough to meet the requirements for fraud in the federal pleadings process, and threw out that part of the case. But it's an interesting case because the Donors Bill of Rights is held up as a aspiration, in my view, as an aspirational document, much more than it is a legal document. Couple federal tax issues which I think are useful to talk about. One is conservation easements. There has been a lot of litigation about conservation easements where people have abused the system. They have bought undeveloped property cheaply. They've come up with a plan. They put a conservation easement on the property so that they can't build it, and they try to deduct the before and after value, which is greater than what they paid for it to begin with. There's a whole string of cases that the IRS has taken against them, and they're very much concerned about those kinds of issues. Donor advised funds, which I mentioned earlier, is another area in which there is significant question being raised publicly about whether or not they should be in some way restricted more than they are. Donor advised funds have existed for years, but they were really first recognized in the law in 2006. The donor advised fund is a fund which is sponsored by a public charity, which accepts the money and holds the money and is the owner of the money. But it allows particular people the donor or a designated advisor to advise on how this money will be spent, and in some cases, how it will be invested. And there are a lot of people who are concerned that people who use donor advised funds get a big deduction in advance and then never spend the money. And they're arguing that there at least ought to be a 5% distribution requirement every year and other kinds of limitations. So far, that hasn't happened. The study that the IRS did about donor advised funds said that they were basically on the up and up and legitimate, and they did not recommend any new regulations. But there is still a great deal of concern among some people that the money is being put into these pots of money and not being used directly for the working charities that would get the money. And so they're arguing that there should be at least a 5% payout rate, which is the payout rate for private foundations, which want to hold their money in perpetuity or just for a long period of time. Watch for the IRS to maybe come out with some regulations on that, some new regulations on that. It's one of continuing controversy. Couple other things to mention that happened in the last year or so. The expansion of the ministerial exemption for religious organizations, where many of their employees are deemed to be ministers in the sense that they are helping to promulgate the faith of the organizations. And if so, they are exempt from the labor laws. The constitutional exemption that the courts do not want to go into the question of the religious doctrine, those kinds of issues. And so many professors, many adjunct teachers, they're all now deemed to be ministers, and they're not subject to the National Labor Relations Act. They're not subject to the Civil Rights Act, the Title VII of the Civil Rights Act, because the courts will not get into trying to tell a religious organization who they should have as the people who are dealing with their doctrine. Another issue, which is not a good issue, particularly for charities in the past year, as you know, most charities, not all, but most charities are required to register before they solicit for charitable contributions. And there are a variety of exceptions, but the ordinary social service organization, arts group, various things like that are required to register if they're soliciting nationally in 39 states in the District of Columbia before they register. There had been a significant effort to get a single portal on the internet where you could file one spot and register in all the states you wanted to register in. There is a uniform registration statement which can be filed in most states when you're filing, with paper filings. They were trying to duplicate that on the internet. The group that tried to do that essentially failed. They had a couple states up for a short period of time. They didn't really work very well. And so there is no effort currently ongoing to have a portal on the internet. And if you're doing it, you have to go and do it each individual state. Unfortunately, more and more states are having their own portal for their own state, but they're not similar. And so you have to do each one of them separately and file it. And it becomes a really difficult task. An interesting case that I thought arose this year involving the Attorney General of Pennsylvania in charge of the Charities Division, who was asked to testify in a criminal trial in Philadelphia, where the allegation was that the executive director ran off with several millions of dollars. And ordinarily, lawyers cannot testify as expert witnesses because the judge is supposed to know the law and you're not supposed to explain the law to the judge, and maybe not necessarily to the jury because the judge is going to do that. But this woman who was charged with wire fraud and various other kinds of fraud charges, but that U.S. attorney got the deputy attorney general to give a treatise, testimonial treatise on fiduciary duty and on what were the obligations of officers and directors of the organization and what was permitted and what was not permitted. And the court ultimately said that that was not testimony on the case itself, not testimony on whether the defendant was guilty or not guilty, but was on the legal environment in which she was operating. And the Circuit Court of Appeals on appeal said that that was okay and that he could give the context of the situation as long as he didn't give his opinion on whether or not fraud claims had been determined. Interesting case, I think. I don't know whether it'll be followed elsewhere, but it certainly was an interesting case. We had a question here a minute ago on what is the responsibility of the board of directors. If you're a new president to a board, are you responsible for what the previous president did or did not do? Well, the answer to that is that you're not responsible for what the previous president did or did not do. You may be responsible for what you do or do not do about it, and whether or not you attempted to clean it up or not, whether you attempted to make it right, but you're not responsible for what somebody else did. There's also a question of what are the legal obligations of board members? And that's a really interesting question. I mean, said simply, the board directors and officers have two fiduciary duties, and these are duties to the organization itself. They are the duty of loyalty, which means you have to put the interests of the organization ahead of your own. And so it's not prohibited to have an economic transaction with the organization, but you don't have any right to rely on the business judgment in that. You essentially take absolute liability in that situation if you have a relationship. I mean, clearly, lawyers who serve on the board sometimes handle litigation or other legal services for the organization. And that's certainly permitted. Sometimes there's a person on the board who will sell you automobiles from his dealership or her dealership, and they sell them at cost. And so that's a great deal for everybody. That's all okay, but you run a risk as an individual because you're breaching the duty of loyalty in a sense when you're doing that. And if you do it wrong and there's a problem, you're going to be separately liable for that. But you have the duty of loyalty. You also have the duty of care. You have the duty to act in good faith in the best interests of the organization as a person of ordinary prudence would do in the same situation. And that's sort of the business judgment rule. And we'll talk about that a little bit later in another case, where the courts really don't want to go into whether boards made a mistake or not, because everybody makes mistakes. The question is, did they act in good faith? Did they intentionally look at the question and deal with it so that they would be acting in the interests of the organization? Or were they so conflicted or so lacking in paying attention that they didn't act in good faith? We had a wonderful case in bankruptcy in Pennsylvania a number of years ago in which the board of a nursing home in Pittsburgh area was ultimately found liable for damages because they did not act in good faith, because they had a finance committee that never met, because they never provided oversight on the CFO who wasn't collecting all the fees to which they were entitled to, and they weren't doing oversight on the nursing home administrator who was supposed to be full-time but was working part-time. They did a whole lot of things that they, or didn't do a whole lot of things that they should have done. And they were ultimately, a number of them were found liable for damages for that. It's not very often that people are found liable for damages. My shorthand for a person who's serving on the board is you do your homework, you show up, and you ask dumb questions. And the asking the dumb questions part of it is the critical part of it. mean, we always argue for the value of diversity on a board. And we argue for the board to have a lot of viewpoints coming in to make the point and to argue the issues and to provide different perspectives so that you can reach the best result for the most people. My favorite story is a friend of mine who was doing board consulting for a healthcare organization in North Philadelphia. This goes back quite a while. But after she had done some of her work, they asked her to come to observe the board meeting. At the end of the board meeting, they asked her what she thought of the board meeting. And she said, well, I thought it was really very interesting, but I was sort of surprised that nobody said anything when your executive director said you were going to get a grant from the Philip Morris Foundation, the cigarette company, or the healthcare organization in North Philadelphia. At which point a doctor on the board raised her hand and said, yeah, what about that? At which point they had a whole discussion and turned down the grant. But nobody on the board had raised the question at the time it could have been discussed. And so my view is that if you're on the board and you don't ask dumb questions, again, you're not doing your job. And it's really the point of the responsibility of the person running the meeting to be sure that people express themselves. And don't just assume that silence means consent, because it doesn't always. And if you haven't developed an opportunity for people to speak, and if it's not part of your culture, then I think you're in some difficulty. I've attended a lot of board meetings in the time I've been working in this sector. And it's very seldom that people have a real significant discussion where there's a vote and where things don't go through normally. But that's my view sort of what you ought to be doing with board meetings. There was a very interesting case in the newsletter, which is in your materials, about again, this is a Philadelphia case, but I think it's illustrative to the question of, to whom is the board obligated? And we have a arts group here in Philadelphia, which owns a small building in the old city section of the city near the river. And over the years, there is a fellow who is an artist whose art primarily involves creating facades of buildings in which he inlays the art with mirrors, with other kinds of colorful objects, with all sorts of stuff like that. But the art is the facade itself. It's not a mural in the sense it's not a painting, but it is like that. It's a surface treatment, which is art and quite famous, and he's quite famous, and these things are valuable in their own way. Anyway, the arts group was losing money, having a difficult time, and it wanted to see if it could raise money by selling its building. And it had an opportunity to sell the building to a developer who would tear down the art structure for $4.5 million or something like that. They had another opportunity to sell it to another arts group for $2.5 million, which would preserve the facade. And the artists and some other neighbors argued really that the boards was obligated, because it was the preservation of arts and promotion of arts group, it was obligated to preserve the facade. And it went to the court, and the trial court agreed with that. But the appeals court said, no, the board has to make its best decision of what is best for the organization. It was not created to have a facade, not created to have an artistic building. And it was up to the board, in the board's discretion, to determine how best to use its assets. And as long as there was no allegation that they had not acted in good faith, there was no personal benefit to them in any of this. It was their decision which counted. And I think that's really an interesting issue. It's an important case because we have so many people in the public who think they know better than you do how to run your organization. And because it's a charity and there is public interest involved, they think somehow that they should be entitled to run it and to tell you how you have to do it. And my sense is that that that's not correct, that in fact, the organization is independent. They may not like the organization. They may decide they're not going to contribute to that organization ever again, or ask other people not to contribute to that organization ever again. But that's okay. They can do that. But they're not responsible for it. And as a matter of law, we have to rely on the people who are responsible so that they can make the decision of how to run the organization. And I think that's the Painted Bride case, which is in your materials. And I think it's a very important one to deal with. A couple of things, other things that I want to talk about, but we'll leave some time specifically for questions at the end. One of the things that Baltimore is now in the midst of is the whole change in nonprofit journalism. I saw in the paper the other day that the Baltimore Sun is somehow going to become nonprofit. It's not clear to me from the article whether the paper itself will be nonprofit. The Salt Lake City Tribune got an exemption approved very recently, this past year. One of the issues, of course, with running a newspaper as a 501c3 organization is the traditional role it has played in advocating for who's going to be mayor or president or senator or whatever the office is can't be done anymore, because as a C3, you're not allowed to participate in an election for or against a candidate at any level. But the other thing is that if you are going to have advertising in general is deemed to be unrelated business income. And if you have too much unrelated business income, you lose your exemption. So when you're dealing with physical newspapers, you have a real tension there. When you're dealing with an internet activity where you only have to pay the staff and whatever it costs to run your internet website for a year, which is peanuts, that's a very different economic model. There are some situations, and we just got exemption for one locally, where the newspaper was given to the charity, which raises funds to support the journalism, but it's owned entirely. The newspaper continues as a for-profit and is run by the charity. And so the newspaper can have advertising. And where you have a local giveaway newspaper, that advertising is critical because you have to pay for that paper and you have to pay for the printing and the distribution and all that kind of stuff, which you don't if you have a website. Website is pretty easy to maintain, and the costs of that are peanuts compared to the cost of distributing. Now, I was prepared to argue that with a local newspaper, a community newspaper, the community advertising is a part of its charitable activity. But I didn't have to argue that because we didn't take that position that it was going to be an exempt organization. But there has been a huge change, and it is continuing. We have lost hundreds and hundreds of local news outlets in the last couple of years because of the costs, and we're going to continue to lose that, I think, significantly again as we proceed with this. But the local journalism is important for us to keep, and the nonprofit sector is clearly going to be important in that area. What other questions do we have here, Michelle, that you want us to cover? Because I have a couple other things I'll talk about in a minute, but see if we can get this.
Sure. Let's see. Okay, one of the questions I see here, Don, is it necessary to be approved as a 501c3 to receive grants and or donations up to a certain dollar amount? I was informed anything over 27,000 is considered a profit.
Well, there's no absolute limits and absolute numbers on any of this stuff. So if you were said anything over a certain amount was a profit, I don't know where that would come from. Somebody had asked how you calculate public support. There is, I don't know whether that question is related to that or not, but there's no absolutes in that. Is it necessary to be approved as a C3 to receive grants or donations? No, you can be a C3 entirely based on funding received from fee for services. So most people who are C3 utilize that to get gifts and grants, but you don't have to. You can live entirely on fee for service income if you want to, or volunteer services. The legal aid societies, which have a lot of volunteer lawyers participating, they don't have a lot of money, but they usually get grants and donations to run the administration of that. But there are public interest law firms who do get fees when they win cases, and that's a significant portion of their revenue source to keep them going.
I see. If awarding grant funds received from a private donor or foundation, should they get a W-9 form from the landlord the funds are being given to?
You would get a W-9 from the landlord because you're paying rent, and landlords have to give W-9s if they're not corporations. So, but you wouldn't make a grant to your landlord because that would not be a charitable activity. I mean, you would pay for the rental. So that would I don't think would be a grant.
And then Tommy, I don't know if you want to unmute and expand on yours. It says, can the remaining 51% of spending be on things like overhead and salaries? So it must have been something specific that Don had touched on.
I think that was probably the 49% for how much you can spend on electioneering with a social welfare C4 organization. And the remaining can be sent for other social welfare activities and overhead and salaries as part of the cost of running any organization. And that's part of the way that you can spend your money and still meet the criteria for your own exemption. So administration is always permitted as a part of that. That's permitted even as a part of the private foundation, 5% level. And it's certainly permitted for organizations which are, which are doing other activities.
I'm actually the one, Don, who put in this public support test because I was thinking perhaps you could explain that to everybody. And the way I was thinking of it is one particular donor, who maybe had founded the organization and was still a major donor, how do you have to parse out something like that, a certain amount that they can, they're capped at?
Yeah, there is an article, there's a ready reference page on the website about calculating public support, which is not free, but anybody who wants to email me for it, I'll be happy to send it to you. Basically, the rule is there are two basic rules for determining whether an organization is publicly supported. One of them is under 509A1 and one is under 509A2. The A1 test is called the donative test, which is basically determined by how many gifts, grants, and contributions you get as part of your total support. And it does not count in that calculation any fee for service income. The key to that calculation is that the money which comes in from any entity which is not a public charity or a governmental unit gets counted as public support only up to 2% of the total. Now, let me try to explain that. This is ultimately a 5-year test, but let's assume that you had, if you get 33 1/3%, you're fine. If you get 10%, You may or may not be fine depending on how much support you are seeking elsewhere. But to explain it, let's assume that you have $100,000 of income over this period. You have two grants of $50,000 each. You have one grant from the Bill Gates Foundation for $50,000. That counts because they're a private foundation. That counts as public support only up to $2,000. And let's say you had another grant, let's say from the Ford Foundation of $50,000. They get to count $2,000 as public support. So your public support would be $4,000 over $100,000 or 4%, and you would flunk the test. Change the Bill Gates grant from private foundation to the United Way, which is a public charity. You got 50% from the public charity because all that goes in the numerator. Then you have 2% from Bill Gates, and you made it because you're 52% public support. You know, if you have Gates at 50,000 and you have 20,000 private foundation gifts or corporate gifts, you've got 5 times, 2,000 each for those smaller gifts, plus 2,000 from Gates, you've got 12% public support. You're in the area where you're really close. But the point is, and that Michelle's trying to make, is that if you have a big donor who is the primary source of revenue for your organization, you can easily have a problem. One of the ways currently to deal with that problem is to have your big donor give that money to a donor advised fund, which is a public charity, and have the donor advised fund grant to your organization. And that becomes all public money and not donor money. Now that is one of the questions before the IRS now.
Yes, thanks for that,
Sorry about that.
Don. I thought that would be helpful to a lot of our organizations. So I
Yeah,
appreciate
and
it.
as I say, if anybody would like that article, then drop me an email or send me a note and I'll be happy to get it to you. It's very comprehensive and I hope it works. I think it works. It's a very hard thing to understand, but as Michelle says, if you've got a single donor, you have to watch carefully to be sure that you're getting other revenue along the way.
Does anybody else have some questions?
Well, let me just mention one or two other things here. I noticed I'm on the list of Maryland nonprofits, and there's a bill pending in the state legislature apparently, which would require a certain amount of racial diversity on boards where the organization gets more than $1 million from the state in grant contracts or other grants. A very interesting concept. There is in your materials a ready reference page on a study, which is also free on our website, about the gender differences in the boards of the large educational and medical associations. When most of us think of nonprofits, and 90% of the nonprofits are the organizations with less than $1 million, the boards of the community nonprofits that we're familiar with are generally fairly diverse. But when you look at the boards of the hospitals and the colleges, they are significantly less diverse, both racially and on a gender basis. And the study that is on our website, which was co-authored actually by my wife, who's been very involved in this question of gender diversity on corporate boards and nonprofit boards, shows that the gender diversity on the big boards of the nonprofits is not nearly as great as it is on the smaller boards. And there's been the same kind of thing with foundations, and there's been a great deal of discussion about that. What's interesting about the report and the ready reference page that you have is it talks about specific ways in which to attract people to come to serve on those boards. And one of the interesting ways, actually for both types of organizations, is they very often tend to look at who are their big donors. And if you're putting your big donors on the board, that's a very different point of view than, than you might get if you had greater diversity on your board. And so there are a number of recommendations there of how to go about attracting particularly women, also women of color, but how to attract people to serve on the board. And basically it requires people to go outside their normal comfort zones and talk to people and talk to people who know where appropriate candidates are. Well, there's no lack of appropriate candidates. There's just a lack of efforts to find them. But it's an important issue, and I think can have important implications really on how organizations are run. The studies that have been done show that when you have a critical mass of women serving on the board, the issues are different. The discussion is different. The points of view that are considered in the discussion are often different. And, you look back at the Boy Scouts and the Catholic Church and the NRA, and you look at the NRA's board, there's very little diversity on the NRA board. It can make a huge difference in the way that things deal with. Okay, do we have any other questions here?
I see one more question, Don. Can you discuss the role of the resident agent?
Yeah, I think the resident agent is a requirement of state law to have somebody located in the state who can be served if you're going to be a defendant in a legal proceeding, who can be served and will get the information to you so that you can respond. Not every state requires that. I'm not sure whether Maryland does require it or not. Pennsylvania, I know, does not. But some states do. And the purpose of the agent is not anything substantive within the organization, is merely a drop box so that people can sue you there. That's really the purpose of it. Okay, well, let me say one other thing, which is in your materials, since we have a minute and a half left, about mergers. Because we often talk about mergers in this field. A legal merger is when two or more organizations legally come together, one of which survives, but the survivor takes on all the assets and all of the liabilities of the one that merged into it. And particularly in this time, that is a risky way to operate, I think. There are other ways which you can functionally accomplish a merger without doing a legal merger and without taking over the liabilities of the organization. You can just change the governance structure. If you have a membership organization, the survivor can be the sole member, or can appoint the board, or you could swap boards so that the survivor's board is the board of the new organization, or at least a majority of the new organization. You can take control of an organization in a way which is very advantageous. I was actually talking with a client a couple of weeks ago who was talking about merging as two organizations, but they really wanted to be able to have two applications for the same grant. So when we talked about it, he was able to take over the board of the other organization doing the same kind of work and continue to make two applications for the same grant with the same grant maker, but still have two organizations. And so there are real values in doing that. And it depends, that article will give you a number of issues that come up when you're talking about merger. But if you're not totally familiar with the organization, you're better off taking it over for a while. You maybe merge with it 3 or 4 years from now, after you're sure there's no hidden liabilities coming out of the woodwork for you. But merger is a thing which is being done a lot. There's a lot more affiliations, but merger itself is a risky business. Okay, I think we've come to the appointed end of this session. So I hope I've given you some things to think about. If you have questions, feel free to ask. And if you'd like to get the free weekly stuff, feel free to sign up on the website anytime.
Thank you so much for speaking with us today, Don. We truly appreciate it. I can say that Don Kramer's nonprofit issues is a staple. It's something that I read all the time, and it's worth taking a look. So thank you again very much, Don, for helping us today.
Thank you.
Thank you, everyone, for participating in the nonprofit conference today. We look forward to seeing you soon. Take care.